Warning, warning, warning. This video is going to be for the extreme real estate geeks. And I guess for those who like to do their proper due diligence before just spending $1 million on who knows what. That's right, in this video I'm going to show you the contract of purchase and sale used here in BC for residential real estate. And I'm going to show you all of the important parts and the parts that are not so important, because it is a pretty foolproof contract if constructed correctly by a professional. But before I do that, I'm going to ask you to please subscribe to the channel if you like to stay up to date on Surrey, Fraser Valley, and Canadian real estate for that matter. And also please make sure to hit the like button to help get this information out to other nerds who want to know exactly what it is they're signing before they even start looking at houses. All right, let's dive into it. So now the first thing you have to know about the contract of purchase and sale in BC is that page number 1 of the contract is not actually a page of the contract whatsoever. It's actually an explanation of what you're about to sign. So it's a very boring page. However, your realtor will likely get you to initial either if you're the buyer or the seller in this little section here. And that has to do with the fact that your realtor is going to want you to sign off saying you understand there are expenses that come with this. And for instance, this side cost to be borne by the seller, it costs to be borne by the buyer are outlined here. So that's probably, even though it's not part of the contract, it is what your agent is probably going to have you initial off on first, so they can say that they told you all about it. If you keep going down, this is all explanation again. This is not actually tying you to the contract. Now, in BC, we've made it really easy. There's a bunch of blanks. The realtor fills in the blanks. All of the fine print, hopefully, for the most part, is going to be standardized. So it is okay in most scenarios to not read it line for line for line for line, because, for instance, you can see here the BCREA, who's on top, the Canadian Bar Association, everybody has looked at this. The boards each have their own version of this. They all have gone over the fine print, and you can rest assured that the fine print is the okay part. And I'll show you some of those pages. I call them the boring pages because there's nothing for the realtor to fill in. However, let's start where the realtor does have to fill in the information, and that's on page 1 of 6. And it starts off by saying, hey, who the heck is actually preparing the offer? That's the first thing. The next thing that gets addressed is who the seller is. Now, generally, the seller will be selling their home, so their address can pop in. This is a point of contention, though. The buyer, their name often goes there. However, most of us agents are too lazy to put the buyer's address in. This can actually be a very negative thing, and the buyer's address should always be there. However, a lot of realtors will say, I'm not going to give you my buyer's address because I want to protect their, let's call it, privacy. Well, guess what? The seller, you're going to know their address. So my opinion is the seller should know the buyer's address as well. I think it's a bit of a scapegoat and probably a little bit of laziness, but we all do it. So there's me preaching. But anyway, so now we got the seller and we have the buyer. The next step is to go to the property. Now, you know your property address as the mailing address, but your property can actually be identified in 3 different ways, believe it or not. So there's their mailing address, which we all know our own mailing addresses, but there's also something called the parcel identifier, or the PID. That is another way. You'll often see the PID on like your tax forms and that sort of thing. So parcel identifier is a second way to verify that you've got the right property. And the third way is actually the legal description. That is the description set forth by the land title. So there's 3 different addresses, if you want to call them that are verifying that you're even purchasing the right property. Because I have had, for instance, a PID be wrong, but the address and the legal description be right. And it is the way to verify that, again, you're purchasing the right property. Next up is, well, everybody cares about the number 1 thing. It's actually bookmarked as item number 1, the purchase price. Now, the purchase price is going to be written 2 different ways. Again, we're verifying correctness here. So you're going to put down numerical, so numbers and commas and dollar signs, and you're also going to write it out like you would on a check. So it's very similar to writing a check. You want it written 2 different ways, so there is no discrepancies of somebody saying, no, that's a 0, not a 6. You can understand why that is. Item number 2 is how much of a deposit would be paid in the event that you actually do remove conditions. However, you will notice here that it says the deposit of blanks, because you can come up with whatever you agree to with the two parties, will be paid within 24 hours of acceptance. Most of the time, someone will add in here, someone being the realtors, will add in that the deposit is paid upon removal of conditions. They will even say how it is to be paid, whether it's a wire transfer or a bank draft or a certified check. It should never be a certified check, and it shouldn't be cash, just so you know. It should usually be a bank draft or wire. Wires become very common here during COVID. And down below, it will say who gets to actually take that money, and it's almost always the buyer's brokerage. The contract is written so that the buyer's brokerage or one of the real estate brokerages gets the deposit and holds it in trust. You would actually have to cross out a bunch of this deposit wording in the event that the seller wanted to hold the deposit directly. Okay, so as I said, this is kind of foolproof because there's blanks everywhere for the realtors to fill out. Now, when you're reviewing an offer on your home or you're making an offer, page 2 is the one that you really, really want to pay attention to, because as you can see here on my screen, it is blank. So anything typed into page 2 is typed in by your agent or by the other party's agent. So you want to verify and read this page line for line. And if you have a lot of fine print, the page 3 and 4 may differ ever so slightly, but the computer program takes care of all of that for us. So anything under item number 3, terms and conditions, you're going to want to read that line for line for line. This is where things like subjects are inserted, if the property is going to be left in clean condition or left in as is, where is condition. All of these acknowledgments as for the buyer and seller are all going to be outlined in terms and conditions. So I recommend, if you're making an offer or reviewing an offer, terms and conditions, line for line for line. We got to read every single line. But in the event that you get to page 3, or it could be other pages by this time, or we start looking at addressing the dates, and we're back into the standard form. So the standard form has the dates that are most important are the 3 dates: completion, possession, and adjustments. I think I've discussed those on some videos, but those 3 dates actually will get outlined here. Possession and adjustments are almost always the exact same day, but completion, well, I'll explain it again here. So completion is the day that the money changes hands. You either give the money or you get the money for your home. But here in BC, possession is often the next day or 3 or 4 or 5 days down the road. So it is written in here exactly what day you'll get the keys and exactly when. Next up are the included items. So in clause number 7, you will include things like refrigerators, stoves, all of the things that are known as chattels rather than fixtures. A fixture is something that is affixed to the wall through a screw and not held under its own weight. The reason something like a fridge needs to be written in here is it can be picked up and moved without doing any damage to the property, so it's known as a chattel. And if any fixture is to be excluded, you can actually see this little spot down here, and it actually says but excluded. Now, a lot of people are worried about getting the property in the same condition as which they viewed it, or things being changed out. Well, luckily, we've got number 8 here that says the buyer will receive the property in substantially the same condition as when they viewed it, and it actually even lays out a date. Now, number 9 onward here is where it gets boring. There's very few, if ever, any changes to this fine print that's put in by the real estate board. It's actually shunned and looked down on if you're going to change the standard forms. So you shouldn't be doing that if you're a real estate agent watching this. All of this stuff should be left in with some exemptions. This is where it talks about all the legalese of taxes and time being of the essence and clearing title. These are lots of questions that we get, but again, it's been figured out through the past. I mean, I saw a contract once when I first started with my partner, Chris. I saw a contract that he wrote in 1991, and let me tell you, it was a page and a half, maybe 2 pages. It didn't have all of this stuff. Well, over the years, they've inserted all of this in, they being the lawyers, the real estate board's counsel, the BCREA, in order to make a more smooth process and a more protected process for all the people transacting in residential real estate. And through page 5, all of this stuff continues, the boring stuff. Now, I will bring in spot 20A here, or line 20A, 20A, and 20AA and 20AB. These were the terms that were actually inserted, believe it or not, by the BC Liberal government last time they were in. It was when the market was going crazy and we were seeing properties flipped. So what would happen is somebody would purchase that property before the completion date, 60 days down the road, 90 days down the road, the property would be sold again because values were going up so high. Well, Christy Clark, before she got voted out, because that's what we do in Canada, right? We vote people out. She made it so us realtors would have to insert a clause that says if the property gets flipped, that the original seller would end up actually getting the money. Now, the reason it's done this way is because they could not change contract law. Contract law says any contract can be sold. However, one thing the government does have is power over us agents to write a contract in a certain way. So inserting that was their way to make sure that properties could no longer be flipped. This is one of the ones that gets crossed out often. You don't just have to cross it out, however, for the reason of flipping a property. If you wanted to say add somebody, or your wife wasn't available to sign the contract because she was out of town on work and you still wanted to buy the property, if you wanted to add your wife to title, this part would have to be crossed out. So it is kind of a silly rule, but it's a rule. What are you going to do? The next most important spot down below in 21 is all about agency and whose agents are acting for who. The seller will acknowledge who their agents are, agent or agents. The buyer will do the same. In the event that there is either limited dual agency or no agency, it actually has to be clarified on this page as well. Now, no agency can still happen. It would be absolutely foolish for you to do it, but no agency is still a thing. It's like going to court kind of without your own representation or your own lawyer, right? So kind of like representing yourself. So you would sign off there as well. Now, number 22, super important. Acceptance is irrevocable. So that means if the buyer and seller both agree that neither of them have any outs. Nobody can say, yeah, I said that, but no, I'm not interested anymore. The caveat to that is if you have a condition for your benefit, then you can actually not irrevoke your acceptance, but you could actually then still back out of the deal. Sellers don't usually have conditions, and this is why the buyer usually has the right to back out and not the seller. Then we're going to keep on going down. Now, at some point in time, you have to say when the offer is open to. And in the future, I'm going to be doing a video specifically just on this section, number 24 of the contract, because it is the most abused term of the contract by all realtors out there. And I'll tell you why that is in another video. It's a whole nother thing. But you have your offer open until a certain time, and the seller has to respond by that time or the deal goes south. So that number or that time has to be written, time and date have to both be written in line number 24. Then you have the buyer sign off. Now the buyer and seller, well, both of them hopefully are signing off, but the buyer and sellers actually have to say whether or not they are a principal or they are a resident of Canada or a Canadian citizen, sorry, for tax purposes. And there's a very good reason for that. In the event that, say, somebody owns a property and they sell the property and they are overseas, if you say that you are a resident when you are not a resident, then what you're saying is the money may be released to you immediately. Non-residents, the CRA will actually hold a portion of that money. I think it's 25% of the overall sale price for things like capital gains. So if you check the wrong box here, you can be in real trouble. And the biggest, worst story that any of us in the industry has ever had is it turns out that the seller of a particular property did not say that they were a foreign national. They actually took all the money. The buyer had no idea. It was not disclosed. So now the seller has left the country with all of the money. And the CRA, believe it or not, you know who they charged the fine to? Not the lawyers, not the people that missed it, not the realtors. The buyer was actually the person who had to pay the taxes owing by the seller who left. So that little spot there of checking on whether or not you're a resident of Canada or not could possibly be the most important term in the contract. There you go. Pretty boring stuff. It's a 6-page document that billions of dollars of real estate transact on every single year. And that's your run through. I hope you found this informative. Please remember to click and subscribe for more updates like this and more exciting ones than this, because this one has been pretty boring. Thanks for watching. Please make sure to hit the like button, and we'll see you in a couple of days.